Sorry for recalling you. I just wanted to ask you, under the federal law, the prohibition from possession, I was always curious about the habitual drunkard, habitual drug user. It says it's unlawful user of or addicted to any controlled dangerous substance.
And that means any use at all on anything on Schedule 1, which by definition of the Controlled Substances Act is any use at all. Anything on Schedule 1 is a prohibited use and has no medical or otherwise allowed use. That includes.
If you get a marijuana conviction in the state, you're prohibited under federal law?
It's not the conviction, it's the use.
So how about if you have a trial where you end up with a PBJ?
That, as long as it's not punishable by the conviction.
2 years.
By
right?
2 years, if it's a misdemeanor.
Right, so the misdemeanor marijuana possession is punishable by a year. So what happens if you get convicted of possession of marijuana? Does that prohibit you? I know that's not the 2-year prohibition, but under the unlawful addiction or use of a controlled dangerous substance, does that get you caught up?
No, not necessarily. If it was a federal conviction, yes, because that's a federal felony. So if it's a state conviction, it depends on how punishable, what's the term of imprisonment is. If it's less than 2 years or less, it's not a disqualifying offense. So it all depends on state law on that and whether it's called a misdemeanor or felony. So it's.
Well, wouldn't that be evidence? Wouldn't your misdemeanor conviction be evidence of the use of a controlled dangerous substance, even though it doesn't carry a 2-year sentence?
Well, remember, the federal law is a user of. So it talks in terms of the present tense. So if you were a past user and you're no longer a user, you're basically free yourself of the disqualification.
So Senator Huff and I have a bill.
I know
that is a little tricky on federal law, but about marijuana, medical marijuana.
Right.
Possessors. How does that play into something? So how has it worked in other states? If somebody is on a list of users of medicinal cannabis and they're on a current list of that, how does that relate to their ability under federal law to get a license?
Those are current users by definition under federal law 922G. They are illegal users and they are prohibited. Indeed, if you look at Federal Form 4473, to purchase a firearm, they have to affirmatively state on that form that they're not a current user of illegal drug, and they specifically talk about medical marijuana on Form 4473. So if you lie on that form, it's a federal felony, that's 10 years. And if you are a current user of marijuana, you're a prohibited person. So as much as the state may want to make it legal under state law, you still have that overlay of federal law, which would bar the very conduct that the state wishes to legalize.
Last question on that. I'm sorry for getting a little off track, but I just was curious. I was looking at this. How about if you have an addiction to a prescription, like you get addicted to Percocet or which is not, a Schedule 1, drug, but you have a current addiction to an opioid or something.
That makes you a disqualified person as well. Now, if you have a prescription by a doctor for an opioid, that's perfectly fine. So if you're on a doctor's care for an opioid, for example, that doesn't render you disqualified under either state or federal law, because the doctor has that's allowed use under the Controlled Substances Act, and it's allowed use under state law. Yes, as long as if it's under a doctor's care, yes. 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 But what's the problem here is that marijuana is still a Schedule 1 under the Controlled Substance Act. That makes any use a prohibited use, because by definition, anything on that schedule there's no legitimate use whatsoever. So if you want to bring federal law into the 21st century, you've got to have Congress change that. And there's a very complicated procedure for the Attorney General and HHS to change it as well, but it's never been used.
Yeah, and I did understand that, and I read your testimony, and that's why yesterday when I said, I understand we can't alleviate the federal, but there is all throughout Maryland's law, it talks about people possessing guns and concealed carry. It's all throughout ours, the same references. So at least with my bill, it would deal with the Maryland side of it. I can't, and I said that yesterday when I testified, I can't fix the federal side because I'm not a federal lawmaker. I think there are some efforts at the federal level to deal with it and change the form. But the point of the bill that I had yesterday was to deal with the state, because there is all throughout our state code too. So
It is.
while they, I guess they would, where I guess it would help trying to think this through is, if not when they go to purchase a new one, but if they currently have a firearm or a concealed carry permit or something, at least they wouldn't be violating Maryland law anymore if we pass this.
That's true. When I went to the state police barracks last month and I saw the demonstration for their new application system for a concealed carry permit, I asked the troopers there, well, what about the people who are current users or marijuana card, cannabis medical users? They said, well, we're not going to tell them. So the risk that you have here, they're not going to tell them that they're prohibited under federal law. Because any use of marijuana, including medical marijuana, is prohibited under federal law. So you're going to give a permit to carry a concealed firearm to a person who has medical marijuana, thereby assuring them that they are a prohibited person under federal law? Gee, what a bad idea. So that's the problem I have with you're basically communicating to a whole host of people that this is okay, when under federal law, it's a felony.
Yeah, but so you have that contradiction 100 times throughout our laws with marijuana. It's all over. It's constant. We contradict federal law, and since we're already operating in that sphere, in my opinion, at least the bill would deal with people that currently own firearms, or currently, at least we would allow that exception in our standard for Maryland law, because I can't affect, as a Maryland state senator, the federal law. But hopefully, even passing the bill would help pressure the feds to do something.
You know, Senator, I understand the sentiments, and honestly, my heart goes out to people like the vets who need this stuff. I will tell you that there's nothing this state can do that will change that, because you can't pressure the feds. I spent 33 years in the Department of Justice, and that's not going to change a thing. So,
well, if you had somebody that was a current, if you have somebody that was currently had possession of a gun and they have one of these permits, I mean, that creates all kinds of problems under Maryland's current law.
it does.
So if we change the Maryland current law and then you currently have a gun and we allow this exception, that alleviates at least that problem.
It will for state prosecutions.
And that's and that's what I want. I mean, the goal of that bill is to not have state police going around and chasing after these people that have these permits. That's basically the goal of it. And I know I can't solve all the problems, but
Well, here's the problem: they can't buy a gun, because every purchase of any gun, long gun, handgun, you have to fill out a 4473, and the dealer won't sell it to you if you answer 11 E's honestly.
I understand that, and the feds have to change that. But at least with possession of a firearm and a medical marijuana card, you won't run into the state police problem anymore.
I think that's certainly true.
So, yeah.
That's certainly true. Yes, Senator Smith.
I appreciate what they're trying to do, but like, is it still the case that the state police would still, I mean, they would still have to enforce that federal standard? I mean, there's no way to get around that. I mean, right,
Well, they are sworn to uphold federal and state law, so yes, they're supposed to. Now, you could tell the state police to ignore federal law, and they'll obey the commands of this legislature. It seems to be kind of like flying in the face of the rule of law.
Yeah, I mean,
So that's my problem with it.
You do that with all marijuana law.
Well, yeah. So I understand the problem, and I wish I had a solution.
We're a little off, but I'm sorry. Go ahead.
No, go ahead. I mean,
I just was wondering because you have there been any legal cases on that? I mean, I assume that this has been an issue in other states. Has somebody gotten jammed up and filed in federal court?
Yes, they have, because there was a case brought in, it's in my written testimony, which you got yesterday, a case called McIntosh, where they affirmed, in the Ninth Circuit, the most liberal circuit in the country, affirmed this ban on possession of marijuana by medical marijuana users under federal law, and on grounds that Congress had a rational basis on which to extend this ban to the possession of firearms. And there's a long discussion in that case about how that obtained. Even in this state now, even though it's decriminalized, you have in my written testimony a citation to the Court of Appeals decision that says it's still not legal. It's only the possession is still not legal. It's still just decriminalized. So if the person, the government, federal government can't pursue a prosecution for mere possession of marijuana under an Appropriations Act But that has a 5-year limitations period on it. So if that appropriation rider were to expire, and it expires every year, the government could go back and prosecute anybody for the last 5 years under federal law. And that is up to the discretion of the Assistant United States Attorney to do that. And I don't trust discretion, I'm sorry. Thank you. My pleasure.